Hi guys, welcome to Learn Kenyan Law with Wanjiku. I am your host, Wanjiku Mwangi. And for today's episode, we're continuing with the series of the law of evidence, and we're still asking ourselves what kind of facts are relevant, especially in our Kenyan law. So we're going to be focusing on Section 6 to Section 16 of the Kenyan Evidence Act because that deals with the relevancy of certain kinds of facts. But for today specifically, we're talking about Section 6. So Section 6 talks about facts forming part of the same transaction. And Section 6 of the Kenyan Evidence Act reads, facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. So basically, Section 6 refers to what forms part of the res gestae. And when we look at the Osborne Dictionary, in terms of what is res gestae, the dictionary says that the facts surrounding or accompanying a transaction, which is the subject of legal proceedings, or all facts so connected with a fact in issue as to introduce it, explain its nature, or form in connection with it one continuous transaction. So the evidence of words used by a person may be admissible on the ground that they form part of the res gestae, which might otherwise be inadmissible as hearsay. So that is what the dictionary says about the res gestae. And again, remember, this is under Section 6 of our Kenyan Evidence Act. And the next thing that I'd want us to talk about is which facts fall within the res gestae. So there are three main groups that res gestae falls within. The first group is acts constituting a series. The second group is acts or omission showing a continuous fact. The third group is acts which are part of one transaction. So let's talk about the first group, which are acts constituting a series. So basically this happens where there's an example maybe of an existence of a custom or usage. So if a particular community is using a specific custom or usage to, go about their day-to-day activities, when you come in court and you clearly say this is a custom or a usage of these people, of course it has to prove, you have to prove that number one, it is practiced by a large number of people over a long period of time. And again, when you want to take it into evidence, these, of course, are acts constituting a series. So you will need to prove by evidence of the acts done over a period. The second group that falls within res gestae are acts or omission showing a continuous fact. So, for example, if the fact in issue is whether a person is insane, of course, the court is going to look at the continuous conduct of that person, since this continuous conduct forms part of the res gestae, and evidence may be given of conduct over a period of time. So if you're trying to prove that you're insane, your lawyer has to indeed show that within this period, which is a continuous period, you've been behaving in this way, and that is why we're saying you're insane. Another example where an act would fall under this group of acts or omission showing a continuous fact, it would be a continuous conduct of you abstaining from, paying creditors. So if there's that conduct of you went to a bank, you took a loan of maybe 10 million, but you're supposed to be paying it in every month, this specific amount, and you've not been paying it, the evidence is going to be used that through this period, you have not been paying whatever it is you're supposed to be paying. Another example which falls under acts or omissions showing a continuous fact is a premises used for prostitution. Of course, for someone to prove that indeed your premise has been used for prostitution, they need to look at the continuous conduct. Rather, how is that, who are the people getting in these premises? Who is renting these premises? So those are acts or omissions showing a continuous fact. The third group and our final group that we're going to be talking about is acts which are part of one transaction. As the name suggests, any act which is part of one transaction and which has many illustrations, it can be both in civil and in criminal cases. We're continuing with our discussion of res gestae, and a statement which the witness has heard may also form part of the res gestae. However, it has to fulfill some of these conditions that we're going to be talking about. First condition, they are nearly contemporaneous, meaning that they were made at the same time or nearly the same time as the transaction which is the fact in issue. So if a statement was made nearly the same time or even exactly the same time, then it might be forming the res gestae. The second condition is that they are explanatory. This is to say that they explain the fact in issue. For example, if it's a physical condition at the time, it is able to explain the fact in issue. If they explain a mental condition at the time, they have to be explanatory. You wouldn't say a statement is res gestae if it's complicated, or rather if it's too wide. So they are explanatory. They explain the fact in issue. We're still saying that statements which the witness had may form part of the res gestae, provided that they are not offered as evidence of the truth of the facts contained in the statements, for they would be hearsay, as the statements were made by persons not called as witnesses. So we've talked about those three things, that a statement which the witness has had may form part of the res gestae. And we're also going to talk about the fact that statements which are made by bystanders and heard by the witnesses who repeats them in court are relevant only if the statements were uttered at the time of the transaction or soon thereafter, as to make it relatively certain that the speaker was still operating under the stress of the occurrence and was not reflecting upon what he said. So basically, we're saying that any statements that have been made by a bystander or someone who heard them, and they are going to repeat them in court as the witnesses, they are relevant only if those statements were uttered at the time of the transaction or soon thereafter. So I'm going to encourage you to read the case of R versus Ratten. It's going to help you understand statements made by bystanders, and we're also going to talk about it. So remember, we're still talking about Section 6. And Section 6 of the Kenyan Evidence Act reads, facts which, though not in issue, are so connected with the facts in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. So the word transaction is important for us to understand. What do we mean when we say transaction? So a transaction is a group of facts that are so connected together as to be referred to by a legal crime, such as a crime, a contract, a wrong, or any other subject to inquiry which may be in issue. And it is also important for us to say that every fact which is part of the fact in issue, even though that fact might not in itself be the issue, is relevant, even though it might be hearsay and it was not part of the transaction. So what do we mean here? Let's delve a little bit and talk about, when you're buying a pen from the shop, that is a transaction. And that transaction ends the moment the buyer hands the money to the shopkeeper. And the shopkeeper hands the pen to the buyer. So when you go to the shop and you're buying a pen and you pay, and then the buyer gives you the pen, the transaction has ended. But in certain circumstances, there are certain transactions, like for example, murder, they extend over a long period of time. And this is where I'd want us to also talk about the fact that a transaction may either constitute a single incident that is, occupying just a few moments, or it may even spread over a variety of acts, declaration, and all those. So all these facts are relevant only when they're connected by proximity of time, proximity of place, continuity of the action, and the community of purpose or design. So that is what we mean when we're talking about a transaction. So again, we say that a transaction is said to end, and when it begins, it depends on the fact and the circumstances of each case. So we do not have like one broad explanation to explain what a transaction is, but it depends. It can be for a short period of time and it can be for a long period of time. And one thing that helps me understand these things are, case law. And I'd want us to first start by talking about the case of R versus Bedingfield. And, in this case, the lady managed to run out with a throat cut, and the lady managed to say, see what Harry has done to me. So when they were in court, the question arose as to whether this statement could be admitted in evidence. So the Lord Justice Cockburn was empathetic that it could not be admitted, and he said that it was not part of the transaction, that it was said after the transaction was over. So remember, the transaction we're talking about is the cutting of the throat. So the judge held that it was not admissible as part of res gestae, since it was something stated by her after it was all over. The girl said those words when it was all over. Of course, when we're talking about R versus Bedingfield, there is a lot of people consider it as a bad law. So because it was actually overturned in R versus Ratten, and we will also talk about R versus Ramathan Ismail. But it is always important for us to know that case, because the judge was saying the words, "See what Harry has done to me," they were said after the transaction is over. And again, remember we've talked about res gestae and all the fulfillments that it has to fulfill. The next case that we're going to be talking about is R versus Premji Kurji. And the words that were said in this case were, "I have finished with you. I am now going to deal with your brother." So the question was whether this statement was admissible as forming part of the transaction. And it was held that they were part of the same transaction, because when two acts of an accused person are so interwoven as to form part of the same transaction, then it is not proper to shut out an evidence of one of the acts, even though it may involve introducing evidence of commission of another offense. So basically in this case, they say that the words, "I have finished with you, I am now going to deal with your brother," they form part of the same transaction, and therefore they are admissible in evidence. The other case that we're going to be talking about is R versus Ramathani Ismail. And the words that were said in this specific case, which is a 1950 case, is "Daddy, this is the Bwana." And you know, the young lady was trying to show the father that this is the Bwana who has raped me. And so the question was whether this statement was part of the transaction. Of course, the transaction here is rape, and it was already finished by the time this lady is going to call her daddy. So the question was whether this statement of "Daddy, this is the Bwana," is it admissible? So the court held that it was not part of the transaction, and the transaction was already over. So of course, different courts have different conception of what forms part of the same transaction, and especially in this case, the court in this rape case adopted a conservative view. So in R versus Ramathani Ismail, it adopted a conservative view of what formed part of the same transaction, which reminds me what we've just talked about, the R versus Bedingfield. And it was a lady having the throat cut, and he said, "See what Harry has done to me," and the court was like, "No, this does not form part of the res gestae, or rather we cannot admit this into evidence, because this statement was already said after the transaction was over. Therefore, it does not form part of the same transaction." Next case law that we're going to be talking about is Temper versus R. And in this case, the words that were said were, "Your house is burning and you're running away." So the question was whether this statement was part of the same, or part of the transaction, as the fact in issue was being arson. And of course, the court held that this was part of the same transaction, so it was admitted into evidence. The other important case that we're going to be talking about is R versus Ratten. And the girl said that the voice on the phone betrayed the emotion. So she was begging to have the police called over, and before the operator could link the woman with the police, the phone hung up on the woman's side. So the question was the statement by the telephone operator admissible as part of the transaction? So the court held that the evidence of the telephone operator, of course, was admissible, and in explaining why, they said that the important thing was not whether the words were part of the transaction, but whether the words were uttered during the drama. So the court also said that the particular evidence of the operator contradicted the evidence which was to the effect that the only telephone call outside of this house during the murder was a call for an ambulance. So in R versus Ratten, the court was clearly saying that the question is not whether the words were part of the transaction, but whether the words were uttered during the drama. So these are really important cases for you to understand when it comes to facts forming part of the same transaction. And we say this is under section 6. We've talked about which acts fall within res gestae, and we've talked about acts constituting a series, acts or omission showing a continuous fact, or acts which are part of one transaction. And R versus Bedingfield is really important. R versus Premji Kurji is also very important. R versus Ramathani Ismail, Temper versus R, and R versus Ratten. And still, when we're talking about the cases which help us understand section 6 of the Kenyan Evidence Act, it's also important for us to note that we have R versus Christie, which is a case that happened in 1914. And in this case, the accused was convicted of indecent assault on a boy. So the boy gave unsworn evidence in which he described the assault and identified the accused, but made no reference to any previous identification. So the House of Lords, by a majority of 5-2, held that both the boy's mother and a constable had been properly allowed to give evidence that shortly after the alleged act, they saw the boy approach the accused, touched his sleeve, and identified him by saying, "This is the man." So the evidence of the previous identification was admissible as evidence of the witness's consistency. So basically they did agree that the boy's act of just going to touching the sleeves of that other man and saying that this is indeed the man who has, assaulted me, it was admitted into evidence. So we also have the case of Thompson versus Trevanion, and this case had to be it dealt with statements made by participants participants who are observers of an event. So in this case, it was decided that what a wife said immediately upon the hurt was received, and before she had time to devise or contrive anything for her own advantage, it was held admissible in evidence. So basically, those cases that we've talked about, they are either talking about whether the statement is part of the fact in issue or not. So guys, that is it for section 6. So thank you so much for joining me. I hope this has been a learning session for you. And in case you feel like you want to contact us, feel free to subscribe, of course. Feel free to write a comment down here. Of course, feel free to also reach out to my email. See you guys. Bye.